This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So the Ninth Circuit Court of Appeals has ruled in favor of Burbank High School's vocal performance choir in a fair use copyright case over whether this plaintiff company, Tresona Multimedia, has the right to sue them or can successfully make a copyright claim over their use of sheet music in their later performance. You know, I don't know if you guys have been in high school choir. Yours truly was one of those bandos and choir geeks in high school. And I played the tuba in band, and I sang bass in choir. And I was in one of those performance choirs, probably a performance choir that was inspired by Burbank High School. Although GLEE wasn't around, there were lots of stage choirs that sang and danced, choreography, competitions, everything, tried to be the best performance choir they could be at the high school level. And I think my choir director, Dennis Smith, Saucon Valley High School, recently passed, so rest in peace, Dr. Smith. I don't know if he ever got his doctorate. Mr. Smith. My high school choir director was obviously inspired by something like the Burbank Performance Choir because we did the same thing. And so I feel a real kinship to this case. What would happen if you bought sheet music and then your students learned the sheet music, learned choreography, put on a whole stage performance and everything, and then along comes Tresona Multimedia and they sue you for copyright infringement? What do you think the judge and the court and everything would do about it? Let's take a look at what Circuit Judge Wardlaw, remember this is in the Ninth Circuit, this is on appeal. In this copyright infringement action against Brett Carroll, the vocal music director at Burbank High School, the Burbank High School Vocal Music Association Boosters Club, several parents, social media, Tresona Media claims that the Burbank High School student show choirs failed to obtain licenses for their use of copyrighted sheet music in arranging a show choir performance. We conclude that Tresona lacks standing to sue as to 3 of the 4 musical works at issue, and that the defense of fair use renders the use of the 4th non-infringing. We therefore affirm the district court's grant of summary judgment in favor of the defendants, the show choir, but reverse the denial of attorney's fees to Carroll and the Boosters Club. Okay, so the Boosters Club gets their attorney's fees. Great. Burbank High School's music education program includes instructional classes and 5 competitive show 5 competitive. We had one competitive show. You have 5? The competitive show choirs, called Out of the Blue, Sapphire, Impressions, Sound Dogs, and In Sync, are nationally recognized as top competitors in their respective divisions and reportedly inspired the television series GLEE. To participate in the show choir, students must be enrolled in one of the 4 music classes offered by the high school during the instructional day and must also make financial contributions to defray expenses, including those for costume rental, competition entry fees, transportation, choreographers, and professional music arrangers. Wow, they even hire professional music arrangers. Not that that sounds out of the ordinary for Burbank, which is basically Studio City, California. They're all in the same area. Disney's there and a lot of others. Universal is there. A lot of studios are there. And a lot of very creative people live and work in LA. It seems to be a mecca. Now, it's not quite a mecca. There's lots of downsides to LA too, which is why yours truly doesn't live there. But there's lots of creative people in LA. Because student contributors do not cover the full costs of the competitive show choirs, and many students at the high school cannot afford to make any financial contributions, the Boosters Club, a registered 501c3 nonprofit, holds several annual fundraisers at the high school to help cover the show choir's expenses. These annual fundraisers include the Burbank Blast, a show choir competition that features performances by 40 show choirs, as well as the Spring Pop Show, during which the Burbank High School competitive show choirs perform their competitive sets. To generate revenue from these events, the Boosters Club sells entry tickets as well as advertisements in the event programs. Now, while you're listening to this, think about the previous lawsuit we did like this, where a California school district parents association showed a Disney movie during a parent-teachers club meeting to the students so that the students would have something to do while the parents were having their meeting. And they were fined or demanded $250 by Disney for each performance of that movie. So compare that to this. Is this the same thing where we are showing a movie to students, or is this where we're making a transformative use of copyrighted material? Brett Carroll is the music director at Burbank High School, where he teaches an instructional day class and directs the show choirs. Carroll also acts as a teacher liaison/coach to the Boosters Club. In this capacity, Carroll decides how the funds raised by the Boosters Club are spent and selects the show choirs, choreographers, arrangers, and accompanists. Carroll also decides, with input from the parents, which competitions the show choirs will attend during the school year. Carroll commissioned music arranger Josh Green, who is not a party to this action, to create custom sheet music for 2 shows, Rainmaker and 80s movie Montage, performed by the group NSYNC. Rainmaker is an approximately 18-minute performance of stanzas from many musical works, including a rearranged segment of Magic, a song performed by Olivia Newton-John. The Magic segment used by NSYNC to close out the last 2 minutes of Rainmaker, so a very important piece, includes a rearranged chorus and small segments from another verse of the song. 80s movie Montage is an approximately 20-minute performance. Holy mac, really 18 and 20 minutes for a single arrangement? And incorporates a segment of the song I've Had the Time of My Life by Bill Medley and Jennifer Warnes. Really? Bill's last name is Bill Medley? I never actually knew who wrote I've Had the Time of My Life. So Bill Medley, a music composer named Medley. Awesome. That segment is approximately 16 seconds of the song's chorus out of the song's 4-minute and 22-second runtime, and is used only once in 80s movie Montage to transition between other songs. Each show also incorporates small segments of several other musical works, none of which is at issue in this case. NSYNC performed these shows on several occasions, including at the Burbank Blast fundraiser and during several student competitions. After NSYNC's performances of Rainmaker and 80s movie Montage, Traysona, an Arizona-based licensing company, brought copyright infringement claims against Carroll, the Boosters Club, and parent members of the Boosters Club, alleging infringement of Traysona's copyright interests in Magic and I've Had the Time of My Life. Traysona also alleged that performances by the John Burroughs High School show choirs at the Burbank Blast, which incorporated segments of Hotel California and Don't Funk With My Heart, let's make sure we pronounce that word correctly, violated its copyright interests in those songs. Traysona alleged that it was the only authorized issuer of the license for the infringed songs in the United States and Canada, and that Carroll, the Boosters Club, and the parents' use of the songs without obtaining a custom arrangement license, a grand right license, a synchronization license, or a mechanical license for them infringed its copyright interests in the copyright law. For real quick, a couple of those. A custom arrangement license sounds like it is what it is. So a license to arrange someone else's song as you see fit. So in other words, if I want to perform a custom arrangement of I've Had the Time of My Life, I probably have to get a special license for that, not just some cover license. A license to cover it would mean a license to cover it accurately. Hence, certain cover songs are completely different, but also exactly the same. Like the lyrics are the same and the chord progressions are the same and everything. And all they've done is just sing it in their own style, as opposed to sing it as a new arrangement, which this is a little bit different. A grand rights license, I'm not even sure what that is, but maybe a grand rights license is like everything. It's a comprehensive license, and that way you can feel free to, arrange, perform, choreograph, and everything, and not worry about infringing. A synchronization license is when you're syncing the audio to video. So that means, I guess they think that they have the right, since you're making your own video, a choreographic, performance, that you need a synchronization license. That makes sense. And a mechanical license, which is basically for a recording of the song as opposed to just a license to perform it publicly. There's also a mechanical license to record it. So here we go. Traysona acquired its copyright interests in the songs through a series of assignments. Penn Music Group, which is not a party, had granted Traysona exclusive non-transferable rights to issue copyright use licenses for Magic. That's not quite the same thing. I think we're going to see this as part of their loss here. The relevant contract defines copyright use licenses as sync licenses, arrangement licenses, grand rights licenses, and dramatic rights licenses. Penn, in turn, had been assigned its rights to Magic by John Farrar Music through BMI. The contract between Penn and BMI states that Penn shall solely own each and all of BMI's interests in the musical composition to the extent that they are written, composed, co-written, or co-composed by John Farrar. John Farrar composed the words and music to Magic and is the sole copyright claimant of Magic according to the Copyright Office's online public catalog of registration. Despite this chain of title, however, it is undisputed that Trasona does not own the public performance rights to Magic. Rather, John Farrar Music has retained those rights as it is the sole owner. Trasona failed to provide evidence of its chain of title to Hotel California. It is undisputed, however, that Penn controlled the only co-owner's interest in Hotel California, the rights to which are jointly owned, and it owns only 25% in I've Had the Time of My Life. Accordingly, neither Penn nor Trasona is the sole copyright owner of its purported interests in either song. As for Don't Funk With My Heart, Trasona was assigned interests from a separate music publisher, the Royalty Network, which is also not a party. The contract between the Royalty Network and Trasona provides that the network grants to Trasona the exclusive, non-transferable right to issue copyright use licenses for Don't Funk With My Heart. However, the record evidence shows that the Royalty Network controls only the author's interests in Don't Funk With My Heart, a work that is jointly owned with 6 other entities. Therefore, neither the Royalty Network nor Trasona is the sole copyright owner of the purported interest in Don't Funk With My Heart. Despite the minimal evidence of Trasona's claim, Trasona brought this action against Carol, the Boosters Club, etc., basically the choir. The district court granted, in part, Carol's motion for summary judgment, holding that Trasona lacked standing to sue for I've Had a Time of My Life, Hotel California, and Don't Funk With My Heart, because Trasona only had non-exclusive rights to these works. Remember, you have to have exclusive rights to the works to sue for copyright successfully. For Trasona's claims based on the song Magic, the district court concluded that Carol was entitled to qualified immunity from the suit. Okay, because he's a state actor, right? Qualified immunity for a choir director. I've never even thought about those words fitting together in the same sentence, but yeah, that makes sense. He is acting on behalf of the state through the choir. So he's a state actor on behalf of the choir, and so he gets qualified immunity if he follows the rule of law. For Trasona's claims based on the song Magic, the district court concluded that Carol was entitled to qualified immunity from the suit and that the Boosters Club and Boosters Club parents could not be held liable for direct or secondary copyright infringement. After successfully defending against Trasona's claims on summary judgment, Carol and the Boosters Club moved to recover their attorney's fees. The district court denied their motions, concluding that the choir director and the Boosters Club had achieved only a minimal level of success, and that an award of attorney's fees would not further the purposes of the Copyright Act. So on the standing issue, the district court and the appeals court are going to grant summary judgment against Trasona for the 3 songs that they claim they don't have an exclusive license. We're going to skip through this a little bit because this is a well-known and really easy to understand thing. Trasona needs to have basically 100% exclusive rights to the copyrights to sue somebody. So if they're just a licensing organization, they don't get the right to sue unless they are properly the exclusive licensing organization, which it appears they're not. So the court says here, under the 76 Copyright Act, the legal or beneficial owner of an exclusive right is entitled to institute an action. Although copyrights are divisible and can be freely transferred, the question of standing to sue depends on the nature of the interest transferred. In the case of joint ownership of exclusive rights in a copyright, when one co-owner independently attempts to grant an exclusive license of a particular copyright interest, that license does not have standing to sue alleged third-party infringers. Trasona received its copyright interests as a license from individual co-owners of those interests without the consent of other co-owners. And thus, the district court correctly held that Trésona lacked standing to bring copyright infringement claims based on the songs I've Had the Time of My Life, Hotel California, and Don't Funk With My Heart, as Trésona received its interest in those songs from individual co-owners of copyright without the consent of the other co-owners, and therefore held only non-exclusive licenses in those works. But here's what we're waiting for. We're waiting for the fair use argument here on the last one, which I think is magic. We affirm the district court's grant of summary judgment against Trésona on its claim of infringement of magic, but not on the ground of qualified immunity. From the outside, that just blows my mind, by the way, that the district court would find that a high school choir director has qualified immunity, as opposed to finding fair use, finding qualified immunity. That he implemented fair use law correctly, therefore he is qualified immune. From the outset of this litigation, Carroll asserted the defense of fair use, and on cross motions for summary judgment, Trésona sought a ruling that there was no fair use. The district court, however, ruled in favor of Carroll on qualified immunity grounds, holding that since teaching is explicitly listed as fair use in the Copyright Act, a public school teacher acting in his teaching capacity would be reasonable in believing the fair use defense applies. So it wasn't whether or not fair use is correct. It doesn't matter. He's a public school teacher, so he gets qualified immunity. That doesn't necessarily eliminate liability for the school district or the choir organization, but the director is not personally liable. Interesting. It thus elided the question, or eluded, or evaded, the question of whether Carroll's use of an arranged segment of a copyrighted musical work in the arranged show music was an infringement. But that question begs to be answered, for show choirs and the arrangements they perform are not limited to public schools, where the defense of qualified immunity might be invoked by public school teachers, and the defense of fair use, if applicable, should cover teaching, whether in a private or public setting. Moreover, the fair use defense renders a use non-infringing, and has long served as an important defense in copyright law, unlike the qualified immunity defense, which has never been used in our circuit or by the Supreme Court to shield a public official from a copyright infringement action. So you're seeing a first here, people. A qualified immunity defense has never been used in the Ninth Circuit Court of Appeals or in the Supreme Court to shield a public official from a copyright infringement action. So we are truly seeing a new argument here for the first time. First recognized by United States courts in 1841, fair use is an equitable rule of reason that permits courts to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which that law is designed to foster. In the Folsom case, Folsom v. Marsh, this one, Justice Story, yes, there was a justice named Justice Story, formulated the issue of fair use as a question of whether this use is a justifiable use of the original materials, such as the law recognizes as no infringement of copyright of the plaintiffs. He identified many of the factors that continue to guide our analysis today: the nature and objects of the selections made, the quality and value of the materials used, the degree in which the use may prejudice the sale, diminish the profits, or supersede the objects of the original work. Although Congress has amended federal copyright law numerous times in our history since the original statute was enacted in 1790, it first codified the fair use doctrine in Section 107 in the Copyright Act of 1976. In doing so, Congress sought to restate the judicial doctrine of fair use in Section 107, not to change, narrow, or enlarge it in any way. Congress, however, acknowledged that courts must be free to adapt the fair use doctrine to particular situations on a case-by-case basis. In Section 107, Congress first provides examples of traditionally non-infringing uses of copyright. Notwithstanding the provisions of Section 106 and 106A, which are the copyrights, the fair use of a copyrighted work, including such use by reproduction in copies or phonorecords or by any other means specified by that section, for purposes such as criticism, commentary, news reporting, teaching, scholarship, research, is not an infringement of copyright. Congress then lists four non-exclusive factors to be considered in determining whether an unauthorized use is infringing. We know these as the fair use factors. This is a balancing test, not a situation where any one factor eliminates the others. The first factor, the purpose and character of the use. The second factor, the nature of the copyrighted work. Third, the amount and substantiality of the portion used in relation to the original. Fourth, the effect of the use on the potential market for or value of the copyrighted work. We first look to whether the allegedly infringing use falls into the categories of uses given by Congress as examples of non-infringing uses. We then turn to the non-exclusive list of factors, looking not only to the statutory language but also to prior judicial decisions. We analyze these factors together in light of the purpose of copyright law, keeping in mind that the copyright's limited grant of monopoly privileges ultimately furthers the public good by promoting the progress of science and the useful arts, which is in the Constitution under Article 1, Section 8, Clause 8. We also closely examine the particular facts presented by this case because the fair use analysis is a factually driven one. Carroll's use of the musical work was in his capacity as a teacher in the music education program at Burbank High School. Such an educational use weighs in favor of fair use, but that does not end our inquiry because the preamble's text employs the terms including and such as to indicate the illustrative and not limitive version or function of the examples given. We next analyze and weigh the fair use factors. In the first fair use factor, the purpose and character of the use, we first look to the purpose and character of the use. Josh Green's arrangement of segments from several musical works, including the chorus from Magic, was for non-profit educational purposes, and the resulting work was transformative. Green's new arrangement became an 18-minute-long competitive choir show, Rainmaker, that included the rearranged chorus of Magic. It was performed by students as part of Burbank's music education program. Part of the proceeds went to the nonprofit Boosters Club to support their other aspects of the music education program and the work of the show choir. This use was not of a traditional commercial nature, but rather of the nonprofit education that the students in the music program enjoy. Carroll distributed the sheet music arranged by Green at no charge to the students. However, the mere fact that a use is educational and not for profit does not insulate it from a finding of infringement. The central purpose of this investigation is to see, in Justice Story's words, whether the new work merely supersedes the objects of the original creation, or if it instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. It asks, in other words, whether and to what extent the new work is transformative. Works are transformative when new expressive content or message is apparent, even if the allegedly infringing work makes few physical changes to the original or fails to comment on the original. The more transformative the new work, the less will be the significance of the other factors. Magic was an original song in the 1980 musical movie fantasy Xanadu. Olivia Newton-John played Kira, a muse descended from Mount Olympus, who encourages and inspires the male protagonist, Sonny, to pursue his dream of opening a fantastical nightclub, Xanadu. Magic plays during their first encounter, reprises first when Kira must return to Olympus, and then again when Kira seemingly reappears as a Xanadu waitress. It is thus used as a vehicle of inspiration for pursuit of one's dreams and love. Rainmaker is an entirely different theatrical work, a showpiece for the high school choir that reworks pieces from multiple songs to tell a story with new expressive content and meaning. Rainmaker tells the story of a local Dust Bowl-era community ravaged by drought. After a stranger visits the town, he promises rain in return for faith in his magical powers, and performs several miracles to encourage the townspeople to believe in him. When the town's last holdout, the sheriff, drops to his knees to proclaim his faith, life-saving rain finally arrives. The townspeople celebrate the newfound rain, singing the rearranged chorus of Magic, including additional new lyrics. This rearrangement of Magic, along with other musical works, was thus transformative. Green did not simply omit portions of the original work while retaining the same intrinsic entertainment value. Rather, Rainmaker uses a portion of Magic by adding new expression, meaning, and message. Because Green's rearrangement of a portion of magic created a new work with new meaning, it was a transformative use. The purpose and character factor of the fair use analysis strongly weighs in favor of a finding of fair use. The second factor, the nature of the copyrighted work, examines whether the work is informational or creative. We keep in mind that creative works are closer to the core of intended copyright protection than informational or functional works. Because the original arrangement of the song Magic is undoubtedly creative, this factor weighs against a finding of fair use. The third factor examines whether the amount and substantiality of the portion used in relation to the original is reasonable in relation to the purpose of the copying. We recognize that the extent of permissible copying varies with the purpose and character of the use. As a result, this factor necessarily overlaps somewhat with the first factor. If the secondary user only copies as much as is necessary for his or her intended use, then this factor will not weigh against fair use. Here, the segment taken from the song Magic is approximately 20 seconds of a 4-minute and 22-second song. The portion that was used, however, incorporates the song's principal chorus, which is the central element of the musical work, and is repeated more than once. Thus, the copied portion is undoubtedly a qualitatively significant portion of Magic. However, as the Supreme Court has explained, in discussing both parody and news reporting, context is key, and the question of fairness asks what else the copier did besides just go to the heart of the original. Even entire verbatim reproductions are justifiable where the purpose of the work differs enough from the original. In this case, Green's rearrangement did not simply copy several lines from one chorus of the song and repeat it, but embedded that portion into a larger, transformative choir showpiece that incorporates many other works and imbues the entire piece with new expression and meaning not contained within any of the individual works. Carroll thus departed markedly from the original lyrics, incorporating the chorus of Magic into a new and different story that also furthered high school students' music learning and development. The new work is not a verbatim copy, nor one in which the transformative use is so insubstantial as compared to the copying that the third factor must be resolved as a matter of law against the defendants. In light of Carroll's non-profit, educational, transformative use of Magic, the amount and substantiality of the portion used does not weigh against fair use. Now that's interesting, because I haven't necessarily seen the courts drag the transformation and the non-profit educational factors into the third factor. But yeah, I see how the court is using the more transformative than the less likely the third factor weighs against fair use, I guess is what they're trying to say there. And then finally, the market usurpation factor. The fourth factor, the effect of the use upon the potential market for or value of the copyrighted work, requires us to consider not only the extent of the market harm caused by the particular actions of the alleged infringer, but also whether unrestricted and widespread conduct of the sort engaged in by defendant would result in a substantially adverse impact on the potential market for the original. In other words, if this Burbank choir song was public, I guess let's just pretend it's only being played at their nonprofit events. Does that impact the sale of Magic? Probably not. But if the Burbank choir did all of this and wrote their own arrangement of Magic, but it was just Magic from beginning to end. It wasn't an 18-minute choreographed thing. It was their own performance of Magic, like a cover song. And there is a compulsory right to cover, so you automatically get a license to cover as long as you cover properly and follow the law. Could they release that cover song? Probably not, because that probably violates the fourth fair use factor too much, in that it is usurping the market. They are directly competing. It's not criticism or commentary. It's educational, but the educational part was for the choir. Not for you, the consumer. So I don't know if they could get away with that. But just performing it at their nonprofit performances for the community and for the booster club, that sounds perfectly fine to me. Let's see what the judge has to say. This inquiry must take account not only of harm to the original, but also of harm to the market for derivative works. When, as here, the use is plainly transformative, market substitution is at least less certain, and market harm may not be so readily inferred. Carroll and the Boosters Club submitted uncontroverted evidence that the sheet music incorporating 20 seconds of magic was used only by students and their accompanists during the show choir's extracurricular activities as part of their performance of the new work. Although the creation of sheet music incorporating the copyrighted work was a derivative use, the 20 seconds used in the Rainmaker choir piece is not a substitute for the song Magic. As Professor Nimmer, a famous writer about copyright, explains, if, regardless of medium, defendant's work performs a different function from plaintiff, then, notwithstanding its use of substantially similar material, the defense of fair use may prevail. Fair use exists when those interested in obtaining plaintiff's music for musical purposes would not find their need fulfilled by purchasing the defendant's allegedly infringing work. A consumer interested in acquiring sheet music for Magic would not purchase the sheet music for Rainmaker, as it omits much of the song except the chorus, and even the portions that are included are substantially rearranged. Similarly, a person wishing to perform the sheet music for Magic in order to play or perform that song would necessarily purchase the sheet music for the song itself from the owner of the performance rights, not the sheet music in Rainmaker. Thus, the use of magic in Rainmaker does not affect the consumer market for the sheet music in the song at all. It is difficult to see how even widespread and unrestricted use of the chorus in the context of non-profit show choir performances could displace the market for sheet music for the entire song. Of course, it is a given in every fair use case that plaintiff suffers a loss of a potential market if that potential is defined as the theoretical market for licensing the very use at bar. However, a copyright holder cannot prevent others from entertaining fair use markets merely by developing or licensing a market for parody, news reporting, educational, or other transformative uses of its creative work. Nor does the decision by secondary users to pay or not pay establish whether fair use exists. Because the use in this case falls within the transformative market, Tresona was not harmed by the loss of any fees for the licensing of the song Magic. We weigh each of these factors in light of the Copyright Act's purpose to stimulate artistic creativity for the general public good. The educational use of magic falls into an enumerated fair use purpose, and 3 of the 4 factors we consider are neutral or weigh in favor of finding that defendant's use of magic was fair use. We are especially swayed here by the limited and transformative nature of the use and the work's non-profit educational purposes in enhancing the educational experience of high school students. We conclude that Carroll's use of a small portion of the song Magic, along with portions of other songs to create sheet music for a new and different high school choir showpiece, was a fair use. So there you go. Then they're going to shift to attorney's fees, and we're going to skim this real quick. Normally, attorney's fees are shifted under Section 505 of the Copyright Act. But the district court denied fees to the defendants because it granted summary judgment on the grounds of standing and qualified immunity. So I think the judge is going to disagree with that. Defendants prevailed across the board in this action and are entitled to an award of fees on their fair use defense. So they examined the test for objective reasonableness and whether Tresona was objectively reasonable in bringing their arguments and claims, and the judge says no, they are objectively unreasonable. Tresona should have known that the cyber sound case rendered its chances of prevailing on 3 of the 4 songs slim to none. On the fair use argument, a different case, Seltzer, found a close and difficult case in an action for infringement is reasonable. Therefore, the band Green Day used a drawing of Scream Icon, a screaming contorted face, in a video backdrop. We explained that the transformation was far from obvious given Green Day's only slight alterations to the original, and each of the remaining three fair use factors pointed in a different direction. The second factor weighed against fair use, the third was neutral, the fourth weighed in favor of fair use. Here, in contrast, the use falls plainly within fair use, and portions of the song taken were used in a highly transformative work. Therefore, Trasona did more than simply pursue an aggressive litigation strategy. It sued a public school teacher, a not-for-profit boosters club, and parent volunteers. Both during litigation and before litigation, Trasona repeatedly mischaracterized its copyright interests. These communications appear significantly designed to frighten instead of to adjudicate a legitimate claim. It was not until after briefing on summary judgment that Trasona belatedly produced any evidence of chain of title. None of these actions furthers the purposes of the Copyright Act. Accordingly, they'll award attorney's fees to the defendants. We therefore award attorney's fees and remand to the district court for the calculation of that award. So they affirm in part and reverse in part. So they reverse on the qualified immunity because you don't really need it. You need fair use instead, and qualified immunity is not the proper way to exonerate a public school director for using fair use. It's a clever way to do it, but I've never seen qualified immunity exonerate somebody in a copyright case. That was a first. And also really cool that that the Burbank High School show choirs have the right to continue doing what they're doing. Not many show choirs, by the way, hire an arranger to make new arrangements just for the show choir. A whole new show, Rainmaker and whatever the other one was called. 2 brand new shows, 18 and 20 minutes long, based on other works, so that the show choir gets a chance to sing and learn and dance and play in a fun and educational environment. I loved my time in my show choir. Ours was called Challenge. We won most, if not all, the competitions we entered, and I feel very much a kinship to the Burbank High School show choir. And so that's really interesting. But that's not the end of it, because now we have a motion from none other than Trasona to stay the case while they appeal to the Supreme Court. I don't think they're going to do very well. Do you think they're going to do very well? Let's take a look. They say, this is Trasona writing, this is not the court, this is plaintiff. Plaintiff appellant Trasona Multimedia respectfully moves the court for a stay of the case, pending the filing and disposition of a petition for writ of certiorari in the United States Supreme Court. The mandate is scheduled to issue May 22nd, so that's last Friday, and a petition for certiorari is to issue August 13th. This case presents a substantial question concerning judicial interpretation of the doctrine of divisibility codified in the Copyright Act, an important issue which greatly affects copyright owners. So they're not upset about the fair use, they're upset about the 3 that were thrown out for lack of standing. It's still going to be fair use, right? Like, even if they have standing in those other 3, they're still going to be fair use, right? Good cause for a stay exists because absent a stay, the parties in the court will be required to spend resources litigating an issue that may prove moot if the petition is granted, namely the remanded issue on fees. Okay, by virtue of the merits determination by this court, the significance of the division. Okay, so they're challenging the standing because then the fees don't shift for those 3 or something. Trasona brought this action alleging they infringed copyrights. We just read it all. Let's see their argument. The stay of mandate is appropriate where a petition would present a substantial question and there is good cause. So they're saying they need not demonstrate that exceptional circumstances apply, and they do meet both requirements according to them. The case presents a substantial question concerning proper interpretation and administration of the copyright statute, particularly in the context of the divisibility of the copyright doctrine codified in 17 U.S.C. 201. The court's reading of the term exclusive in the context of the divisibility doctrine prohibits a third party who has received exclusive rights or an assignment of its rights from a copyright co-owner from standing in the shoes of a copyright co-owner on a copyright infringement claim. Cybersound has been extensively criticized in the leading copyright treatises or writings or books or articles, including, among other things, the treatises of David Nimmer and William Patry, and outright rejected in at least one court not bound by this circuit, so outside this circuit, with criticism thereof noted in numerous other court decisions. That is because the term exclusive can apply to a divisible right and to a grant by only one co-owner, and its restricted interpretation to rights or grants by only 100% of the copyright owners of a work runs counter to the statutory divisibility scheme. Indeed, the interpretation of exclusive to connote the ability to prevent anybody else from exploiting a copyright fundamentally conflicts with the understanding that more than one party can possess the same exclusive right to exploit. Prominent industry groups have rallied in support of Tresona's challenge to Cybersound, further demonstrating the substantial challenges presented by Cybersound to music creators and music rights organizations. The amicus brief in support of rehearing was filed by the National Music Publishers Association, the Nashville Songwriters Association International, the American Society of Composers, Authors, and Publishers, ASCAP, and Broadcast Music Inc., BMI. These organizations are significant stakeholders within the music industry, and their participation on this appeal speaks to the broad ramifications that this issue has on music creators and their rights holders. Thus, notwithstanding this court's decision not to rehear the case, the issue presented remains a highly important question of statutory construction that affects the enforcement and administration of the Copyright Act, which is the type of issue ripe for review by the Supreme Court. There is also good cause for a stay of mandate pending the filing of writ of certiorari. Indeed, the same reasons that compelled a stay pending the petition for rehearing compel a stay under these circumstances. While the mandate requires the parties to continue proceedings as to attorneys' fees, that issue is inextricably intertwined with the merits of this case and may be rendered moot if the judgment is modified. Appellees will not be prejudiced given the narrow import of mandate and the durational limit of the stay, and entering a stay will avoid a potentially conflicting lower court judgment and the further use of resources on an issue that may otherwise be rendered moot. I think that's a lot of mays. I think that's a lot of speculation. I'm not sure the Supreme Court is going to grant certiorari, so I'm not sure if they're going to stay this case while the Supreme Court grants it. I'd like to see Burbank High School and the others who paid for attorneys' fees, I'd like to see them get their money back while Tresona pursues certiorari in the Supreme Court. So let us know what you think of that. The choir wins. The educational purpose trumped all of the alleged copyright infringement. Does that mean that anybody can just go write their own arrangement and perform it in a show choir? No! It has to be a high school show choir or an educational show choir. It has to be not a commercial entity doing a for-profit performance. It has to be a non-profit educational performance, is what that tells me. Really interesting. Really enjoyed that one. Let me know what you think in the comments below. Were you in a show choir when you were in high school? And what did you think of your choir? And what did you guys do stuff like this, or did you do something different? I think it's really cool that they hire an arranger, Josh Green, to write a whole new arrangement of music and all that. I think our directors did that too in both band and choir, but I'm not sure that they hired outside arrangers. I think they were always the director themselves or a student. So let me know what you think. So thank you for joining me. I'm Leonard French, your favorite copyright attorney, and thank you for your financial support. This is a community-supported legal education channel that would not exist if it weren't for the monthly financial support of our viewers and listeners on patreon.com/ljfrench and sponsors.com/law. I love this huge list of $50 plus supporters that get shouted out at the end of our show. In May, the $50 plus supporters are Joe Tyson, Wes Delj, Nicely Done Defense, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, Ugly Grill, Shielo T, Josh Baker, Gregory, and Rudolph Bescherer Jr. And thank you to the $5 plus supporters. Everybody, including the $50 plus supporters, scroll on that LED panel and everybody gets a crawl on the end of the videos that drop. I'm Leonard French, your favorite copyright attorney. I hope everybody has a great week. Summer is just starting here in Pennsylvania, and I'm really happy to get out. I'm looking forward to the coronavirus restrictions being lifted at some point so I can go see my fiance and maybe even get married. Until then, I love you all, and I'll see you in the videos that drop. Bye.